Landmark legal decision, Abood v. Detroit Board of Education of 1977 by Alyssa Stunsel. 1970 social perspective. This was a period in time when the society was fighting for equal rights, whether that be for the women or for their political rights as citizens. The education system also fought for their rights as well. Before I get into the case, there are a few terms that should be defined. Collective bargaining. Collective bargaining is negotiation of wages and other conditions of employment by an organized body of employees. Agency shop clause is a form of union security agreement where the employer may hire union or non-union workers, and employees need not join the union in order to remain employed. However, non-union must pay a fee to cover collective bargain costs. Free riders are people who take advantage of being able to use a common resource without paying for it, without paying their share of taxes. The First Amendment, Congress will not make laws prohibiting the free exercise or abridging the freedom of speech or press. The 14th Amendment addresses citizens' right and equal protection of the law. What caused this case to arise? The Supreme Court case of Abood v. Detroit Board of Education came about due to whether agency shop clauses violated the constitutional rights of government employment, including school teachers, who do not believe that the public sector should be unionized or who disagree with the certain activities funded by their union through dues or service charges. In other words, certain teachers objected the union's use of the service fees to support economic, religious, political, and other activities and programs of which they did not agree to. These activities were not in their negotiated wages, and the teachers felt that the use of these services fees violated their First and 14th Amendment. The case began November 9th of 1976, and the final decisions were made May 23rd of 1977. The Supreme Court ruled that agency shop clauses do not violate the First and 14th Amendment if the service fees are exclusively used to fund collective bargaining. Collective bargaining, just a reminder, is negotiations of wages and other conditions of employment by an organized body of employees, or activities and programs outside the collective bargaining to which non-union employees do not object. Based on the Abood, agency shop clauses cannot be sanctioned as a vehicle for unions to compel ideological conformity through the payment of service fees by public employees. The ideology in question need not be political, but could be social, ethical, economic, or of some other type. Employees are legally permitted to disagree with their union's ideology. But Abood clarified that objecting non-union employees have a constitutional right to withhold payment of any agency service fees that support political and ideological causes they do not want to be a part of. In other words, the court explained that objecting non-union school employees can be compelled to pay only those expenses directly related to their negotiated wages or services that they negotiated on. Mandatory agency service fees may not be used by unions to subsidize ideological or political causes or perspectives. Based on Abood, all public employees have a constitutional right to prevent a union from spending part or all of their required agency services on political contributions or costs associated with advancements of political views that are unrelated to the union's duty as an exclusive bargaining representative. After this case was decided, 9 years later another case was brought to the U.S. Supreme Court, the Chicago Teacher Union versus Hudson. The justice held that specific and proper procedures must be in place to protect agency service fees from being improperly used by unions. Basically, Hudson reinforced Abood. In Hudson, the court found further that unions must hold dispute agency service fee money in escrow while resolving worker dispute before an impartial decision maker. The court considered it essential for unions to provide an adequate information concerning the portions of financial cost charges specifically for their negotiated wages to employees who object to any agency service fee they do not want to pay for. And even after the two cases, the union still did not clarify their activities to union workers. A third U.S. Supreme Court case, Lenhart v. Ferris Faculty Association, the court attempted to provide even greater clarity concerning union activities that may not be supported by agency service fees. In the case, the court discovered that up to 90% of the National Education Association, NEA, and local union fees were being charged to objecting non-union faculty members and being spent on union activities unrelated to their negotiated wages and activities. Lenhart again upheld the legal principles that objecting the non-union school employees cannot be compelled to pay for a union's lobbying, organizing, public relations, or any activities not directly related to their bargained wages that they negotiated for. Because of this case, students, teachers, and many other workers are impacted still to this day. Teachers are still trying to find ways to stand up against the union. They are finding new ways to pay for different things for what they want to pay for. Students, the passage of No Child Left Behind Act in 2002 requires states to collect and distribute information pertaining to students' achievements, has helped bring more attention to legal issues associated with the collective bargaining practices. But specifically in our society today, union opponents are seeking to reverse the 1977 Supreme Court decision that allows employee unions to collect the so-called fair share fees. This does not impact just educators, it impacts police officers, firefighters, and even healthcare. Also, in addition, the state legislature have tried to carve out certain matters that are not subject to bargaining at all. Specifically, the union cannot bargain over our pension or even our tenure. Because of the 1977, the Supreme Court upheld mandatory fees for non-union members as constitutional. The court said they were justified by the state's interest in maintaining labor peace and eliminating free riders who gained benefits without paying their fair share. A reminder, free riders are people who take advantage of being able to use common resources without paying for it. So without paying their share of taxes, they want to take from, teachers, police officers, firefighters, healthcare to kind of get that fair share fee. But in recent years, 5 Supreme Court justices have signed on the opinion strongly hinting that they are ready to overturn this precedent.